All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Welcome back. Court officer, please call the case.
Thank you, Mr. President. The situation in the Republic of Mali in the case of the Prosecutor versus Ahmad Al Mahdi. Case reference ICC 0112-0115. For the record, we are in open session.
Thank you so much. The court will now take appearances from the parties. We start with the prosecutor.
Good morning, Mr. President, honorable judges. The prosecution team is represented today by Merichel Rege, Appeals Counsel, Mary Jane Sardeshti, Trial Lawyer, Yayoi Yamaguchi, Associate Legal Advisor, Sarah Okuyoi, Assistant Legal Officer, Sanya Bukelich, Case Manager. My name is Hisham Murad, Trial Lawyer. Thank you very much.
Thank you. And for the victims, please.
Merci, Monsieur le Président.
Thank you, Your Honors. The representatives of victims are as follows: Ms. Lydia Elhal, who is providing assistance to me and myself, Mayambo Kasongo, counsel.
Kasongo. And for the defense.
صباح الخير سيد الرئيس السادة القضاة.
Good morning, Your Honors. My name is Mohammed Awouni, Senior Counsel representing Mr. Ahmad Al-Faqi Al-Maded. With me today is Sylviane Glodgignon and Judith Akebe. Thank you, Your Honor.
Thank you. And for the trust fund for victims, please.
Good morning, Mr. President. The Trust Fund for Victims today is represented by Ms. Erin Rosenberg, Associate Legal Officer, Ms. Andrada Matswanu, Legal Intern, and myself, Peter Deban, Executive Director. Thank you very much.
Thank you. On the 27th of September, 2016, following an admission of guilt, the Chamber convicted Mr. Al Mahdi of the war crime of attacking protected objects as a co-perpetrator under Articles 8(2)(e)(4) and 25(3)(a) of the statute. 10 protected objects were attacked in Timbuktu, Mali, between around the 30th of June 2012 and the 11th of July 2012. All these were historic and religious mausoleums and mosques, and all but one of them were designated by UNESCO as World Heritage Sites. Today, the Chamber will summarize its award on reparations following this conviction. This order sets out 1, the applicable reparations principles, 2, the findings on the harms suffered in this case, and 3, sets Mr. Al Mahdi's liability. The Chamber will also give preliminary considerations to guide the implementation of this order. This order will be released in writing today at the end of this hearing in both English and French. Very special thanks to the translation unit for making it possible to render the order simultaneously in both working languages. What I will read out today is only a summary of this order. The authoritative language for today's order is that which appears in the written decision. In rendering this order, the Chamber considered the observations of the prosecution, the defense, the legal representatives of victims, representing the 139 reparations applicants, the Trust Fund for Victims, the Registry, the 4 appointed experts, and amici curiae, including UNESCO. The Chamber will now address the importance of cultural heritage as an essential component of the charges against Mr. Al Mahdi. The Chamber also recalls briefly the principles on reparations and applicable law underlying its order. Because of their purpose and symbolism, most cultural property and cultural heritage are unique and of sentimental value. As a result, they are not fungible or readily replaceable. The destruction of international cultural heritage thus carries a message of terror and helplessness. It destroys part of humanity's shared memory and collective consciousness and renders humanity unable to transmit its values and knowledge to future generations. Reparations in the present case are designed, to the extent achievable, to relieve the suffering caused by the serious crime committed, address the consequences of the wrongful act committed by Mr. Ahmadi, enable the victims to recover their dignity, and deter future violations. Reparations may also assist in promoting reconciliation between the victims of the crime, the affected communities, and the convicted person. As a general principle, all victims are to be treated fairly and equally as regards reparations, irrespective of whether they participated in the trial proceedings. This said, during the implementation phase, it may be appropriate to prioritize reparations to those victims who were the most harmed by the convicted person's conduct. Whenever possible, reparations should reflect local cultural and customary practices, unless these are discriminatory or exclusionary, or they deny victims equal access to their rights. As indicated by one of the Chamber's appointed experts, women and girls may face gender-specific risks, challenges, and discrimination in gaining access to and defending cultural heritage. I will now proceed to the order for reparations against Mr. Al Mahdi. First, the Chamber will explain who are the relevant victims for the purposes of its assessments. In its judgment, the Chamber concluded that the destruction of the protected buildings affected not only the direct victims of the crimes, namely the faithful and inhabitants of Timbuktu, but likewise people throughout Mali and the international community. However, the Chamber has noted that the degree and nature of harm suffered varies for each of the three groups identified. It is self-evident that the community of Timbuktu suffered disproportionately more harm as a result of the attack on the protected buildings. The Chamber only received reparations applications pertaining to the community of Timbuktu. No application has been submitted solely for the interests of the national or international community beyond Timbuktu. Notably, UNESCO itself did not submit any application for reparation and stated instead that local communities are the principal victims. Nevertheless, the Chamber is well aware of the specific nature of the crime for which Mr. Al Mahdi was convicted. The destruction of cultural heritage erases part of the heritage of all mankind, and the Chamber finds it appropriate to acknowledge the suffering endured by the Malian community and the international community as a whole as a result of the destruction of the protected buildings, all but one of which were UNESCO World Heritage Sites. The Chamber considers that addressing the harm suffered by the community of Timbuktu will also effectively address the broader harm suffered by Malians and the international community as a whole. If the Chamber limits its harm assessment only to the Timbuktu community, that will also maximize the effect of the reparations awarded. In the words of one of the appointed experts, since ultimately it is the local population that is in the best position to preserve the heritage in question, therefore the measures of reparation might most sensibly be aimed at strengthening their capacity to do so. I will now proceed to the kinds of harm suffered, the types of reparations, and modalities. The Chamber will summarize its analysis on the different kinds of harm to the community of Timbuktu in the information before it. The Chamber notes the defense's argument that it is necessary for the Chamber to identify the specific eligible victims to be in a position to subsequently evaluate the harm. The Chamber rejects this argument to the extent that it assumes that reparations can be assessed only on the basis of individual applications. As regards individual reparations, and as discussed further, the regulations of the Trust Fund for Victims specifically contemplate awarding individual reparations in cases when the court does not identify individual beneficiaries. As regards collective reparations, when considering whether the number of victims in a case makes a collective reparations award more appropriate and consistent with the appeals chamber in Lubanga, the chamber is not limited to the number of victim applicants before it. 5 harms are discussed in today's order. The chamber will summarize its findings on each. We begin with harm to the protected buildings and the apology. First, the chamber analyzed the damage caused to the 10 protected buildings in this case. The attacks on the protected buildings lie at the heart of this case and form the basis for Mr. Al Mahdi's conviction. The defense submits that when considering reparations for repairing the protected buildings, the chamber should take into account the fact that they have been restored. The chamber is unconvinced. The fact that the protected buildings have been restored by UNESCO and others has no impact on whether Mr. Al Mahdi is liable for the damage caused. Remedial efforts by a third party in the time between the destruction and the issuance of the reparations order do not alter the amount of damage originally caused. To place undue weight on restoration work would be to understate the amount of harm actually caused and the corresponding reparations required. The fact that UNESCO has no intention of collecting any reparations is likewise immaterial. The Chamber will not speculate on the extent to which the bona fide third parties may assert their rights against the convicted person once the reparations order is issued. The Chamber's only role at this point is to decide on the convicted person's liability, taking into account the scope and extent of any damage, loss, or injury caused. Accordingly, the Chamber finds that Mr. Al Mahdi is liable for the destruction of the protected buildings. As for the types and modalities of reparations needed, the protected buildings belonged to the entire community of Timbuktu, and their loss was felt by the community as a whole. The Chamber considers that collective reparations are the most appropriate way to address the damage caused. As for the modalities, the Chamber considers that the harm caused by the destruction of the protected buildings will be satisfactorily addressed by measures for their protection and maintenance. The Chamber emphasizes that these reparations should be tailored to the individual concerns regarding each of the protected buildings. As regards the damage to the protected buildings, certain applicants, the LRV, Amici Curiae, and appointed experts, stress that there are victims in the present case who view Mr. Al Mahdi's apology as insufficient. The Chamber recognizes that it is ultimately up to each individual victim to decide whether he or she considers Mr. Al Mahdi's apology sufficient. This is inevitable and eminently understandable. But the Chamber must engage with the sufficiency of the apology on some level in order to determine what reparations are appropriate in this case. The Chamber has already concluded that it considered Mr. Al Mahdi's apology to be genuine, categorical, and emphatic. The Chamber does not order any further apology, above and beyond what Mr. Al Mahdi has already given. However, as a symbolic measure to ensure that all victims have access to Mr. Al Mahdi's apology, the Chamber orders the registry to produce an excerpt of the video of the apology and post it on the court's website, with a corresponding transcript translated into the primary languages spoken in Timbuktu. If any of the victims wish to receive a hard copy of the apology in a language they fully understand and speak, the registry shall make this available to them upon request. Further ways of using Mr. Al Mahdi's existing apology may be advanced by the trust fund during the implementation phase of the present order. I now proceed to the consequential economic loss. The Chamber's appointed experts say that the general consequential economic loss caused by the attack reverberated across the entire community in Timbuktu. The Chamber considers that the award caused by Mr. Al Mahdi's actions is primarily collective in character. It is much larger and of a different nature than the harm suffered by the 139 applicants grouped together. Aggregating their losses and prioritizing their compensation would risk dramatically understating and misrepresenting the economic loss actually suffered. Nevertheless, the LRV argues that compensation should be given to all reparations applicants who suffered financial losses, and that a further 250 euros be granted across the board to each victim applicant to address their collective harm. When focusing on the extent of compensation, the Chamber considers it more equitable to use individual reparations to compensate victims on the basis of the extent of the harm suffered or sacrifice made, rather than solely on whether or not an applicant had applied for reparations. The Chamber notes that reparations applicants in the present case already obtain several procedural advantages which are not necessarily available to other members of the Timbuktu community who suffered similar harm. These applicants will have their claims considered first in the screening procedure that the Chamber will address later. And by virtue of having already prepared applications and supporting materials, these applicants can take part in the screening procedure without significant additional effort. Moreover, the applicants provided information considered by the Chamber in tailoring the reparations award, giving them more influence over the parameters set in the present order. The applicants also continue to avail themselves of the assistance of the LRV, a court-appointed lawyer who receives legal assistance to represent their interests and advocate for them. However, going beyond these procedural advantages by compensating the applicants to the exclusion of similarly harmed people puts undue emphasis on the filing of applications rather than on the extent of the harm suffered or the sacrifice made by the victims. There is no reason to believe that the reparations applicants, simply by virtue of applying, suffered to a different degree compared to the rest of the Timbuktu community. As noted by the LRV himself, there is a large risk of frustration in awarding reparations solely to those who have reparations applications pending before the Chamber. The Chamber's appointed experts also recommended that reparations should be awarded on a collective basis as far as possible. Accordingly, the Chamber awards individual reparations for consequential economic loss only to those whose livelihoods exclusively depended upon the protected buildings. An individualized response is more appropriate for them as their loss relative to the rest of the community is more acute and exceptional. The Chamber considers that the number of victims and the scope of the consequential loss make a collective award more appropriate for those beyond this identified group. This is not to say that individual businesses and families could not receive financial award in the implementation of collective reparations. As indicated by the Appeals Chamber, the decision not to award reparations on an individual basis does not prejudice the individuals who filed individual reparation requests with respect to their eligibility to participate in any collective reparations program. Therefore, the Chamber considers that the economic harm caused by Mr. Al Mahdi necessitates individual reparations for those whose livelihoods exclusively depended upon the protected buildings, and collective reparations for the community of Timbuktu as a whole. As for the modalities, the Chamber considers that individual reparations are to be implemented through compensation to address the financial losses suffered. the modalities for collective reparations should be aimed at rehabilitating the community of Timbuktu in order to address the economic harm caused. Collective measures in this regard may include community-based educational and awareness-raising programs to promote Timbuktu's important and unique cultural heritage, return resettlement programs, a microcredit system that would assist the population to generate income, and other cash assistance programs to restore some of Timbuktu's lost economic activity. I will now proceed to the moral harm caused by Mr. Al Mahdi's crime. Every victim applicant before the chamber alleges some sort of moral harm as a result of the attack. The chamber considers that the victims established to the requisite standard the following forms of moral harm. First, mental pain and anguish, including losses of childhood opportunities and relationships among those who fled Timbuktu because the protected buildings were attacked, and second, disruption of culture. The LRV argues at length that the moral harm suffered is best addressed by giving compensation to the applicants as individual and collective reparations. For the same reasons provided when discussing consequential economic loss, the Chamber considers such a compensation-centric approach for the benefit of the reparations victims to be problematic. The Chamber again emphasizes that it considers that such a course understates the variety of other information proving that Timbuktu's community at large, and not only the victim applicants, suffered harm. The Chamber considers that the community-wide impact of moral harm is minimized by the defense when it argues in its submissions that psychological harm in the present case can be proven only by asking for a direct kinship between the people claiming the harm and the deceased whose mausoleums were attacked. The Chamber agrees with the defense, and the LRV for that matter, that those whose ancestors' burial sites were damaged in the attack, such as the descendants of the saints, have a different kind of emotional connection to the destroyed sites than the rest of the Timbuktu population. The Chamber therefore considers that individual reparations through compensation are necessary to address the mental pain and anguish they suffered. But the remainder of the reparations awarded to the entire community of Timbuktu must be collective in character. The Chamber therefore orders that the moral harm caused by Mr. Al Mahdi necessitates 1. Collective reparations for the mental pain and anguish of those whose ancestors' burial sites were damaged in the attack, and 2. Collective reparations for the mental pain and anguish and disruption of culture for the Timbuktu community as a whole. As for the modalities, the Chamber considers that individual reparations are to be implemented through compensation and collective reparations, through rehabilitation to address the emotional distress suffered as a result of the attack on the protected buildings. These collective reparations can also include symbolic measures, such as a memorial, commemoration, or forgiveness ceremony, to give public recognition of the moral harm suffered by the Timbuktu community and those within it. Fourth and fifth, the Chamber analyzed allegations of bodily harm and damage to property other than to the protected buildings. The Chamber convicted Mr. Al Mahdi only for directing an attack against the protected buildings. The common plan underlying this conviction was to attack these sites only. He was not convicted of any crimes against persons or other damage or other property damage, nor did the Chamber make any factual findings along these lines. The Chamber considers that many victims allege bodily harm and other property damage, with only the most summary of assertions that this happened during the attack, making it difficult to ascertain the circumstances of these acts and how they occurred in the course of the attack. This makes it impossible to tell if these harms were caused by those attacking the protected buildings with Mr. Al Mahdi, or by others in a manner which he neither knew of nor could reasonably anticipate. At times, the lack of detail also makes it unclear whether reparations are being sought on account of harm suffered in the attack on the protected buildings, or on the contrary, on account of other events that occurred during the occupation of Timbuktu. On the basis of the information before it, the Chamber does not consider that these harms suffered were sufficiently foreseeable as to conclude that Mr. Al Mahdi's crime is their actual and proximate cause. As such, the Chamber orders no reparations for these two harms. In this regard, the Chamber emphasizes the relatively narrow scope of this case relative to the wider range of human rights violations alleged to have occurred in Timbuktu and elsewhere throughout Mali. Mr. Al Mahdi cannot be held responsible for these broader tragedies, but the Chamber encourages the Trust Fund for Victims to consider acting under Rule 98.5 of the rules to provide general assistance to those affected. To summarize, the conclusions on the harm suffered. The Chamber finds that Mr. Al Mahdi's crime caused three kinds of harm to the requisite standard of proof. First, damage to the protected buildings. Second, consequential economic losses. And third, moral harm. Although the Chamber recalls its general consideration that it has limited its assessment only to the community of Timbuktu, it notes the LRV's request to award nominal damages to the Malian state for the harm suffered. With regard to the considerations stated previously, the Chamber considers a symbolic gesture of this kind to be appropriate and further directs that the Malian state receive €1 as part of their reparations award. Similarly, the Chamber considers that one symbolic euro should equally be granted to the international community, which is best represented by UNESCO, given the specific nature of the case. I will now proceed to the scope of liability. The Chamber notes the defense's argument that the amount of reparations should be a set and reasonable amount that reflects Mr. Al Mahdi's financial abilities. Given that all the information before the Chamber confirms that Mr. Al Mahdi is indigent, accepting this argument would entail setting Mr. Al Mahdi's liability at or near zero. The Chamber disagrees that Mr. Al Mahdi's indigence has an impact on its reparations award. The Appeals Chamber has determined that it is an error to conclude that a convicted person's indigence is relevant to whether he or she should be liable for any reparations awarded. Taking such circumstances into account would inevitably lead to understating the harm suffered and depriving the victims of their right to a remedy. A convicted person's financial circumstances may affect how a reparations award is enforced, such as by affording an option to make reasonable payments on installments. And the Chamber does not intend to impose hardships on Mr. Al Mahdi that make it impossible for him to reintegrate into society upon his release. But the enforcement of reparations awards is under the auspices of the Presidency and is beyond the current question of setting Mr. Al Mahdi's personal liability. In this connection, the Chamber is not persuaded by the defense submission that it is within the Chamber's competence to limit the term of imprisonment, the time period within which the Trust Fund for Victims is authorized to claim any reimbursement from Mr. Al Mahdi. No such power can be derived from the statutory scheme or from the Lubanga Reparations Appeals judgment. Even if setting such a limitation was possible, the Chamber considers it would be unfair to do so, After all, it is Mr. Al Mahdi, not the trust fund, who is responsible for the harm caused to the victims. The written order discusses the relevant figures advanced to the Chamber by its appointed figures, considering other information and adjusting these figures as needed. The Chamber does not consider it necessary to decide whether its conclusions on the applicable figures constitute the sum total of harm suffered in the course of the attack on the protected buildings. Its conclusions are specific to Mr. Al Mahdi and what it considers to be a fair assessment of his liability alone. Mr. Al Mahdi, after adding up your liability across the various kinds of harm caused by your crime, the Chamber sets your total liability at 2.7 million euros. The Chamber will now proceed to discuss the implementation of this reparation award, understanding that you are indigent and mindful of the role of the trust fund. Mr. Al Mahdi is liable for this amount in expenses for individual and collective reparations. The Chamber has also ordered some symbolic measures. The Chamber notes the trust fund's mandate as an implementing agency upon being seized of a reparations award, and considers that the present order is the first of 3 Chamber determinations to be made during the reparations proceedings. Following this order, the Trust Fund for Victims will propose a plan to implement the Chamber's order, including the objectives, outcomes, and necessary activities that comprehensively respond to all of the reparations modalities that can be realistically implemented. The deadline for this draft plan is set in the disposition of the present order, and the plan will be subject to the Chamber's approval in a second decision. Upon approval, the Trust Fund for Victims will then identify discrete implementation partners in order to implement the Chamber's award, and in a third decision, the Chamber will approve the selected projects. Bearing all this in mind, the Chamber will not give detailed information about the implementation component of the reparations phase. However, the Chamber will advance the following preliminary considerations to guide the implementation of its order. First, noting Mr. Al Mahdi's indigence, the Chamber appreciates that it is within the trust fund's discretion to complement any individual or collective reparations. The Chamber encourages the Trust Fund for Victims to complement the individual and collective awards to the extent possible, and to engage in fundraising efforts to the extent necessary to complement the totality of the award. Second, the Chamber notes that the modalities of reparations it has ordered mutually reinforce each other. In other words, addressing the discrete moral harm may have residual effects that ameliorate the discrete forms of economic harm and vice versa. As such, the Chamber does not consider that the TFV is limited to the Chamber's intermediate liability calculations set out in the written order when designing an implementation plan, but only to its final determination on Mr. Al Mahdi's total liability. Third, the Chamber emphasizes its view that the limited number of individual reparations ordered should be prioritized in implementing the award. The TFV's general position is to prioritize collective awards, but as indicated above, the groups identified by the Chamber for individual reparations are singled out because of the particular extent to which they were harmed by Mr. Al Mahdi's conduct. The Chamber would like this prioritization to be reflected in the implementation case to the extent possible, insofar as individual reparations do not hinder broader reconciliation or stigmatize individual victims vis-à-vis the community of Timbuktu. Fourth, recalling its previous findings on a wide variety of harm suffered in the present case, the Chamber notes that the number of victim applications that it has received is a fraction of the number of persons who were actually harmed. The Chamber has received only 139 applications during the reparations phase, despite determining that collective harm was suffered across Timbuktu, a city of approximately 70,000 people, around the time of the attack. The LRV acknowledges that the victims whom he met on his assignment in Mali represent just a fraction of the victims in this case. The Chamber also notes the information received that the security situation in Timbuktu makes traveling there or contacting victims difficult. For these reasons, the Chamber considers that the names of all the victims meeting its parameters for individual reparations are simply not known, and considers that it would be impracticable for the Chamber to attempt to identify and assess them all itself. In these circumstances, the Chamber will not make such an assessment when awarding individual reparations, making administrative screening through the TFV an approach that is compatible with the statutory framework. As also recognized by the Appeals Chamber, the regulations of the TFV explicitly contemplate individual reparations for unidentified beneficiaries side by side with other TFV regulations on individual reparations in cases where the court identifies the beneficiary. When the court does not identify the beneficiaries, it falls upon the TFV to establish a verification procedure to determine that any persons who identify themselves to the TFV are in fact members of the beneficiary group. The Chamber considers that proceeding in this manner is an alternative to an application-based process whereby the Chamber assesses the reparation requests of identified beneficiaries filed pursuant to Rule 94 of the rules. For these reasons, the Chamber considers that the impracticability of identifying all those meeting its individual reparations parameters justifies an eligibility screening during the implementation phase. Some general parameters for this screening are set out in today's order. Fifth, the Chamber has received conflicting information about the extent to which traditional justice mechanisms should be used in implementing the Chamber's order. Some note the paramount role these play in Timbuktu's culture and how the validity of any reparations order depends on using them. Others emphasize that certain traditional justice mechanisms in Timbuktu have a history of discrimination, especially against women, and that care should be taken in relying upon them. Given this conflicting information, the Chamber will not require that traditional justice mechanisms be part of the implementation of this award. Lastly, the Chamber emphasizes that implementation of the present order must be responsive to local conditions while being consistent with the Court's reparations principles, including the principle of non-discrimination. The TFV is expected to devise a draft implementation plan bearing this dichotomy in mind, consulting all relevant stakeholders, including the parties, and recommending any implementation measures it considers appropriate. The parties will also be given an opportunity to file written submissions on the draft implementation plan proposed. As emphasized, the TFV's discretion in drafting the implementation plan will be subject to approval by way of a second decision of this chamber. I will now proceed to the disposition. To conclude, the chamber will now read out the disposition of its order. For the following reasons, the chamber first orders individual, collective, and symbolic reparations for the community of Timbuktu as specified in the relevant paragraphs of the written order. Second, acknowledges that the destruction of the protected buildings has caused suffering to the people throughout Mali and the international community. Third, assesses Mr. Al Mahdi's liability for these reparations at 2.7 million euros. Fourth, encourages the TFV to take steps to complement the reparations award and provide broader assistance for victims in Mali. Fifth, orders the registry to comply with the symbolic measures in relation to Mr. Al Mahdi's apology forthwith. Sixth, sets a deadline for the TFV's draft implementation plan for 16 February 2018. And seventh, directs the LRV and Defense to file any observations on the draft implementation plan within 30 days of its notification. This concludes the Chamber's summary and today's hearing. The Chamber wishes to thank again the interpreters and the other registry staff in facilitating this hearing. This hearing is adjourned.
All rise, veuillez vous lever.